The next Supreme Court case to consider MEPA was Nestle. In this case, the court limited the scope of a MEPA action and shifted MEPA's focus away from the environment by making it about the injury to the plaintiff. Turning first to the scope, the court effectively limited the area that a MEPA claim can cover. In Nestle, a citizen group sought to stop a water bottling company from pumping groundwater in an area north of the Tri-Lakes region in Mecosta County, Michigan. That's the region that's pictured on this slide. Nestle obtained permits allowing it to pump up to 400 gallons of water per minute. The citizen group argued that Nestle's water pumping and bottling activities would damage the surrounding environment. The trial court found that the pumping reduced the flow of the water and reduced its levels in the affected area's lakes. It also found that these effects would lead to various ecological impacts in the entire area. The court concluded that the citizens demonstrated sufficient damage to the environment to merit an injunction against Nestle's pumping activities. The Supreme Court disagreed. It drew a distinction between two parts of the affected area. For clarity, we'll call one part the lakefront area and the other part the connected area. The lakefront area is the area that touched land that's actually owned by some of the members who were part of the citizen group. The connected area is linked hydrologically or underground to the lakefront area. The court accepted that the plaintiffs did have standing to bring an action with respect to the lakefront area, but they did not have standing with respect to the connected area. So what's wrong with making this distinction between the two areas? Well, in several respects, it just doesn't make sense. Here's a cross-section of an area in which water pumps have been installed. The diagram demonstrates the interconnectedness of all of the resources in the pictured area. In Nestle, the trial court found as fact that many of the streams, lakes, and wetlands in the Tri-Lakes area were joined by a hydrological link. They are all connected. The Court of Appeals called this the complex, reciprocal nature of the ecosystem. It recognized that the water sources in both areas were connected and interrelated with one another. They were all affected by Nestle's pumping. When water levels become lower in some of the water bodies, then they also become lower in the water bodies in the connected area. The Supreme Court ignored the implications of the hydrologic interconnection, and instead, it chose to limit the MEPA action to the lakefront area alone. It said that only the plaintiffs who had an interest, who actually resided on the lakefront area or participated in activities on the lakefront area had standing to bring the claim. The court's reason for holding that plaintiffs had standing with respect to the lakefront area was that the pumping affected their property rights, and therefore, as owners of the land that touched the affected water resources, they suffered an injury that was different from the general public. As for the connected area, the court found that the plaintiffs lacked standing to protect it because they were not harmed from that area. This new focus on the plaintiff changes MEPA at its core. It contradicts the constitutional mandate to protect the environment. It also contradicts the purpose and the intent of the legislature for MEPA, as we are told by the very individual who drafted the statute's text. In the words of Justice Weaver, the court has mistakenly or intentionally replaced the clear mandate of the will of the people of Michigan with irrelevant, misinterpreted, and non-binding federal laws. Now let's review how MEPA has changed. Before, any person could bring a MEPA claim. MEPA was a model piece of legislation that placed environmental protection in the hands of Michigan citizens. Now, to bring a MEPA claim, a plaintiff must pass through the hurdle of a standing test that contradicts the intent of both the Michigan Constitution and the Michigan legislature. Before, MEPA gave citizens broad authority to protect the air, water, and natural resources of the state. Now, plaintiffs can only protect a more limited area. Before, the environment was the focus of a MEPA action. Now, the focus has shifted to the injury that a harm inflicted on the environment imposes on the plaintiff. These decisions outraged many citizens, and hopefully they'll outrage you as well and inspire you to do something to save Michigan's resources. Fortunately, I'm told that in response to MEPA, former Governor Milligan and a group of environmental activists, including Professor Hall of this law school, are working on a constitutional amendment that will guarantee citizens the right to protect the state's environment. A constitutional amendment explicitly permitting citizen suits cannot be struck down by the court. We, the citizens of Michigan, still have the opportunity to stand up for the natural resources of our state and for our right to protect them.